a well-known expert in this area, a scientist, technologist, and academician who applies an innovative polytechnic approach to teaching law to help create lawyers for today's biggest societal challenges. He interestingly integrates science, technology, engineering, and mathematics in his work on areas such as e-discovery, legal analytics, blockchain, cryptocurrency and law, introduction to legal technology and innovation, legal process improvement, etc. He spearheads new initiatives to teach law students how to leverage technology and entrepreneurship in their future legal careers. Professor Katz has publications in a wide variety of academic outlets, including Science, PLOS ONE Scientific Reports, Journal of the Royal Society Interface, Journal of Statistical Physics, Frontiers in Physics, Physica A, and so on. He's also actively involved in the rapidly growing legal technology industry as the co-founder and Chief Strategy Officer of Lex Predict, which is a legal technology analytics company, and advisor to a number of legal tech startups. Lastly, he's a member of the advisory board of Nextlaw Labs, a global collaborative innovation ecosystem organized with Dentons, the world's largest law firm. So thanks a lot, Dan, for joining so early in the morning from the US. And over to you for your remarks. We're all eagerly waiting to hear from you.
Thank you very much. I'll start sharing my screen here. Make sure that we're good to go. Looking good? Okay. Well, for my opening salvo, I'd like to begin with what I think is a fairly obvious statement, which for some might be characterized as a provocative statement. Law just is engineering. It's just engineering. However, today it's a particular type of engineering implemented in a particular manner. And the question, as I see it, or one of the questions, is to what extent the field of law might benefit from insights offered by traditional STEM academic fields, science, technology, engineering, and mathematics. So for the benefit of our multidisciplinary audience, I thought it might make sense to start with the broadest possible question, which is, what is the purpose of law and legal institutions? What is their purpose? People could debate this, but I would say in general, societies create rules to try to govern different types of social, economic, and political behavior. And societies create governance institutions devoted to various legal tasks, things like this: making rules, interpreting those rules, enforcing those rules. This is some of the institutions that have been built and designed. Now, of course, because this involves humans, these processes aren't exactly always neutral, but at a high level, and of course, top-down governmental rules are far from the only drivers of behavior. There are social norms and other factors that drive the behavior we observe. But the guiding purpose is in the rules that are being created, interpreted, and enforced is to help engineer certain types of behavior and to prevent and minimize other forms of behavior. So I hope you can see in just this opening salvo that this is a grand engineering challenge. And it's a challenge to which those beyond the traditional field of law are well poised to make a collaborative contribution. So by way of introduction, I appreciate the introduction. I'll say a little bit more about myself. I'm an academic. I teach at Illinois Institute of Technology, another school named IIT. We're in Chicago, Illinois. I'm also affiliated faculty at Stanford Codex. So in my work, I focus on using scientific methods to study the law. And so I'm a scientist and technologist. These are some of the things. This is my new book on legal informatics that I edited. So bringing the tools of informatics to law, some of the other things that I've done. I'm a teacher. I teach a series of polytechnic courses at Illinois Tech that are focused on threading law and technology together. And as I'll say a little bit later, because there's been a little bit of an awakening in this field of law globally in terms of the use of putting law and technology together, there are programs now around the world I teach in these four at IE, at Singapore Management University, at Bucerius Law School, which is in Hamburg, Germany, and at the University of Toronto. And I've been involved in the legal industry directly. I do a lot of thought leadership. This was the last conference I spoke in person before COVID started. And I'm also involved in the innovation space as a venture advisor and investor and a consultant. And the final thing I'll say is I'm also an entrepreneur, and I sold my company to another company called Elevate back in 2018. Now, why am I saying all this to you? Because if I'm sitting here about to listen to this, I want to understand who is it I'm hearing from, and what basis do they have to basically provide information to me. And all I want to say is I say these things to try to help orient some of my commentary. And the biggest thing is, sometimes you see a faculty member, a law faculty member talking about engineering. I'm not just a spectator. I've been materially involved in the things I'm going to discuss. And so I have skin in the game, and I just wanted to have said that at the outset. So what I'd like to do is share some of my notes from the field with you today. So first thing I want to talk about is the complexity challenge. So whether you're a big company, a small business, or an individual citizen, anywhere basically I go in the world, law has this complexity challenge. The individual citizen says, I have no idea. There are all these rules. I don't know quite how they affect me. And people just have, at best, an impressionistic understanding of the law. And that's a complexity challenge. And if you take a step back, if we look at what is it that drives the demand for lawyers, or what you might call more an economist way of talking about it, demand for units of legal production, meaning a lawyer to review your contract. I mean, that's a unit of work, let's just call it. A lawyer to help you with a dispute with a landlord, a lawyer to help you sell your company, whatever it happens to be. Complexity is one of the big demand drivers. If things were simple, I wouldn't need to hire lawyers. I could do it myself. Complexity is the driver, one of the drivers for demand. So social, economic, and political complexity manifests in our domain as legal complexity. New technologies come along, new societal developments, and rule makers create rules and regulations designed to try to manage the world in the ways that I discussed at the outset, and that creates layers and layers of complexity. And so it's kind of hard to define this, again, I appreciate we have a pretty wide audience here, from, people and traditional lawyers all the way across to engineers and everything in between. So it's pretty hard formally to define complexity. But, that's been a big focus of my focus intellectually has been on this idea of, can we characterize legal complexity in a more formal manner? Here's what I'll say about it, having worked on it for over a decade. It's hard to define, but in virtually every way you might cut it, legal complexity has grows and grows and grows. So I'll highlight a couple recent papers just to have said a little bit about it. These are two recent papers. Here I'll come back to this in a minute, but this is the U.S. and Germany, and studying their legal systems and the rules and regulations. And so there were quite a few rules in 1998, for example, in the United States, quite a few rules and regulations. Now there's, almost twice the number. It almost doubled. There's like a legal inflation rate, just for my economists here on the. There's a rate at which the law grows, and this has not been done globally in every jurisdiction, but I think the story will hold pretty much everywhere, especially if you ask individual folks or small businesses or companies, how do I navigate the rule environment? It's pretty substantial. So I think the question is, you could just reduce the number of laws. That'd be one solution. I don't know if that would really achieve the other goals people have in a society. So the question, as I see it, is how do you match the complexity with the appropriate mitigation tactics, complexity mitigation tactics? So The machine that brings us this webinar has obviously an elaborate amount of code that's helping orchestrate all this. A lot of that is shielded from the user. So how do we create tactics to mitigate complexity? Well, one thing is you can take people, process, and technology and engineer them to have a more fundamental, let's say, better throughput in the way that was discussed earlier on. You can design more scalable systems from first principles. But the legacy model in law has been just put more people on every problem of complexity. The challenge is that sort of reaches its practical limits and its economic limits at some point. So this is kind of what's the source of all this complexity? Technology is the source of the complexity at some level. New things come along or what have you. Technology is sort of part of the problem. It has to be part of the solution. So my view is the approach has to be more fundamental. It can't just be, well, we'll hire more lawyers, we'll hire more judges, and that'll solve all the problems. I think it's more fundamental. The best of science and technology have got to be part of the solution set here. So I have some more thoughts on this here. By the way, I'll make these slides available, so just sort of let it wash over you if you don't mind. But here I try to talk about what are the complexity mitigation strategies that are out there. So now I want to talk about modeling. And I want to talk about 6 flavors of modeling, because one of the things you see in the sciences and engineering is the use of models. And so I want to discuss a series of ideas associated with models and focus specifically on the modeling of legal systems. So I looked at the call that for projects that was there, and here are the 4 things that were highlighted: modeling the justice system, tools to make the laws more accessible to citizens, case durations and outcome prediction, case flow management, and the scientific scheduling of cases and work allocation for judges. I think these are 4 very good things to focus on. What I want to sort of highlight is all 4 of these actually involve models. All 4 of these involve modeling. So when we say modeling the justice system, that can be an independent idea, or it actually touches all 4 of these things in one form or another. So maybe I can just say what actually is modeling. And again, it's a little tricky to define, but because the term actually means different things in different academic fields. And so I want to do a little bit of a translation exercise for everyone, because what happens is, evolutionary biology has models, and physics has models, and economics has models, and all these intellectual fields have different flavors of models. Even process engineering is a model-based kind of paradigm. Building software is based on a model of the world. So all of it is a model in different sense, but I want to highlight the different flavors of models that are out there. But here are some of the elements that you see in models. A model is a representation, some sort of representation of a system. It likely involves an abstraction of that system. It can be used to understand both the components of a system and their connections to one another. And there are various flavors of models one can use. So I want to highlight today 6 different forms of models that are relevant for the analysis and improvement of legal systems. And I just want to say that each of these models I'm going to discuss that are more formal, maybe they should manifest in software or they manifest in mathematics somehow, but all of them have a mental model that goes with it too. We have a model of the world between our ears that we're constantly refreshing at some level based on information. So every one of these you can say, well, the software developer has a view of how the system works, and therefore their mental model gets refracted into the system that is built in software, just as an example. So there are also different scales at which models operate. So I heard the economist who was on earlier, talking about macroeconomics versus microeconomics. Well, models operate at different scale. Microeconomics that involves models at the micro scale, and then there's macroeconomics at the macro scale, and things in between. So I want to start at the highest level, the macro, and go to the micro over the 6 flavors. So we'll take the 6 flavors of models and we'll look at them at these different scales. So one thing you can do the first of the 6 types of models is you can look at the law itself at the aggregate level. Now, I've already given you a little bit of a preview of this approach a second ago with the mention of complexity, but you could just take all the rules in a legal system and you could build a representation of them, a formal representation of them. And you could do that statically at a given moment, and you can look at it over time, how it plays over time. So let me give you an example. This is the German Civil Code. Okay, that doesn't matter whether you can read the words in German here on the page, but what's important is this is a representation. This is the law, and this is a representation on the other side of how you might characterize that. The law has a hierarchy to it, very common thing, which is, rules are kind of nested in a hierarchy, and the hierarchy is meant to organize the information at some level. There are connections between the laws. Doesn't have to be this way, but typically is. There's a reference network because you could either restate the same principle over and over again, or you could just connect it by a reference, by a citation. And there's a sequence graph where kind of items that are more closely located, that are more topically related. The problem with these hierarchies is they get put in place at a given moment in time, and the world changes. And so you're editing a thing that's moving. And any legislature doesn't typically just wipe all the law away and start over. They edit the thing as it's moving. And so you can model this. So here's some examples. Here's an example from France of people modeling legal systems outputs. Here's one from Hungary. Now, part of this is ultimately these models, the output is help people find what they're actually looking for. That's one of the values of these models. This is analysis from the European Union. Here's some work I've done in the US on our federal law, the US Code. What I did in this paper is we looked at one snapshot in 2010 and kind of explored its complexity. In a more recent paper that came out last year, we did it over 25 years, but in 2 countries, and we modeled that over time. And one of the things we did is if you just take the taxonomy of the law that you're handed, then what's happening is whatever the hierarchy was at the time it was created becomes the structure for all of time. But the problem is the world changes, and so the question is, how do you algorithmically reorganize? The ultimate goal is to give the person who's looking for information the right information. How do you algorithmically reorganize this information? And so one of the things we do in this paper is use a well-known information theoretic approach called map equation, which comes from this paper cited down below. But you can reorganize the law into these quotient graphs and then track that over time as it evolves. So you can actually see the development of the law over time. Now, one of the things I want to say about these models, some are more practical and immediately usable, and some provide a different type of representation. But the value add here is help people find what they're looking for and understand how things change over time. The next thing we did in this set of papers is add all the regulations. So, laws can be passed by legislatures, by parliaments, or they can be done in the regulatory state. Different countries privilege one approach over the other. The U.S. uses the regulatory state quite a bit as the means to sort of deliver law or to specify law to certain contexts or conditions. Germany does more of it through code, but it's exclusively one or the other. And this is sort of shows you that is what's the relative share of statutes to regulations? Well, you can see the 2 countries split on that particular topic. Now, I just want to flag for you, those 2 papers are pretty detailed and involve lots of information, and that's just federal legislative and executive, executive agencies in those 2 countries. But there's all the gray squares that aren't even covered here. So when we talk about overall legal complexity, there's a whole nother scale beyond this. So there's always macro, and then there's macro, I guess. It's another way of saying it. But just to kind of connect this all for folks, again, appreciating that we have folks that from kind of purely lawyers all the way across to purely engineers, and trying to connect all that. If you look at this, we have a bunch of different things in play. You have information theory, network science, and to some extent natural language processing, which are intellectual disciplines and subdisciplines that are brought to bear on this otherwise problem or that involves law. So the second modeling approach I want to highlight that's out there is you can look at the performance of a legal system at the aggregate level. So first I was looking at the laws themselves. Now I want to look at some performance measures. This is a question lots of people have asked. This isn't my academic area to do this, but I just want to flag this because I'm trying to provide an overall, representation of what's out there. So people look and say, well, how good is the legal system in a given country? It's a reasonable question to ask. And can we compare legal systems based on some quality measures? This is something people do. It seems like these are reasonable questions. And then another thorny problem in that area is, how do you combine individual measures of quality into a composite measure? So as an example, the judiciary might be very good, but the executive agencies are not from a rule of law perspective or something like this. Well, how do you combine those things? Do they get a medium grade because one's great and one's not? I mean, it's not clear what the answer to that is. But it's these and other related questions which NGOs and researchers and others are regularly seeking to answer. And it turns out these questions are not easy to answer, but there's a lot of measures which attempt to broadly characterize fidelity to concepts like rule of law. And what people would like to do is move from I know it when I see it, which is kind of hard to to something that's more objective and more generalizable. But that's a model. That's a representation of a tremendous amount of activity rolled up into some composite measure. Again, it's much easier said than done. Here's just some examples I'll send you to take a look at of papers and projects on this subject. So the World Bank has spent a tremendous amount of money and effort over a long period of time trying to characterize fidelity to rule of law across the world, and including governance broadly, which includes rule of law, but other things as well. There's this World Justice Project, which has an index of the rule of law, and that's a measure of an entire system, all that activity rolled up into a measure, and then they have submeasures therein. Again, this isn't my area. I'm just trying to provide a portrait of what's out there. And I think it's a good paper which sort of raises some of the issues that are out there about rule of law and measures of rule of law. Okay, the third type of modeling is to empirically evaluate individual legal rules or individual pieces of public policy. As an intellectual field, law has faced a credibility revolution, by which I mean lawyers, judges, and policymakers have gone around and crafted these legal rules and doctrines, and critiqued other legal rules and doctrines without really, historically, there was no empirical focus on the real world performance of these rules and doctrines. People wrote essays. There's a sort of snarky way of describing it where it's basically a comparative essay contest with no anchoring to what's happening in reality. Meanwhile, you look at the sciences and the social sciences where they're actually go out and try to measure stuff and see how things work out in real life. And so that's a critique of law, which I think is a very valid critique, and so do others. And so about 25 years ago, some sense earlier, if you look at law and economics as a field, but there really was what has been called an empirical turn in legal scholarship. You see more and more papers which use data, at least in part, to support arguments for rule modification or evaluating the performance of individual or groups of legal rules. So legal scholarship has become far more empirical in nature. And in fact, there's a Journal of Empirical Legal Studies as an example of that. And there's a Society for Empirical Legal Studies. And you see more and more legal scholars globally that have some interest or expertise in using data to analyze the performance of legal rules. And if you look, across the world, we see a lot of schools with centers about empirically studying the law, which I think is a great development, by the way, for the field of law. And it's closing the gap between law historically as a field and the rest of, let's say, the university as a field, which at least the more scientifically oriented part of the university. So here's what people are really focused on in this area. They want to look at whether a given policy intervention actually does what it says it's going to do. So you go measure it. And, you know, what approaches are being used? Well, what you typically see is quantitative social science methods, mainly methods from econometrics that are being used to measure, to evaluate programs and public policy, legal policies. So the methods can be kind of starting at kind of just relatively simple regression models to fancier stuff in the econometric toolkit. Here's just some of the kind of methods you would see out there in some of the papers. You know, the challenge in policy evaluation is that you can't, it's hard to run. I mean, a lot of these methods are trying to get something akin to a randomized control trial, an RCT, but it's hard to do an RCT in real life because it's hard to have truly laboratory type conditions. And so people are trying to use a bunch of methods to get as close as they can to something like this. Now, these methods, in my view, are great if your goal is to link cause and effect and keep out other effects that might be confounding the performance of something. So linking cause and effect is the key here. Here's just a few papers that leveraging empirical methods. These are just ones I picked. There's many, many more. There's probably thousands more of them literally out there. But here's a paper that evaluates changes in the civil pleading rules in the United States and see how what happened in reality when those rules changed. Here's a paper with a series of bankruptcy scholars exploring a change in the U.S. bankruptcy law. One of them's in the United States Senate now, and the other one's I believe in the House of Representatives. So people went on to great things after this paper. I'm sure this is what sent Elizabeth Warren to the Senate. I kid, but the point is, they want to say, look, we passed changes to the bankruptcy law. What actually happened in real life? Very valid thing. Here's a paper looking at the expungement of criminal records. And so things like this, these are just meant to be illustrations, not an exhaustive list by any stretch of the imagination. Okay, fourth type of modeling. The fourth type of modeling is simulation-based analysis of legal rules and policymaking. So you can use empirical methods. They're typically used to say, we've already done something in the world. Let's see if it actually worked. So it's already happening in the world, and then people are trying to analyze whether the outcomes are really working out in the way people had hoped, okay? But one thing you could do, alternatively, is do simulation. So sometimes policymakers would like to understand in advance, like, what are the likely impacts? And build simulation type models or theoretic models, could be game theoretic or otherwise, that try to understand how people will respond in a real situation. So the alternative to kind of post hoc, after the fact empirical evaluation is to build upfront simulation models. And there are a lot of different approaches to do simulation models, formal simulation models. So game theoretic models are simulations of a sort because they're trying to say, here's how people's strategies will unfold given payoffs in a context. ABMs you can think of as a generalization of that, which loses some of the takes some of the limitations of paper and pen formal models. There's also system dynamics models which you could use, which makes a lot of sense in things like stock and flow problems, which you can think of, the case scheduling issues is really kind of a stock and flow type issue. So you can build models using these. Again, I'm not doing even close to justice to this. I'm just trying to create, a broad sweep here. Now, one thing that shows up in simulation models is what, when I used to teach this many years ago, is what we like to call the uncanny valley in simulation models. So let me just show you what I mean by that is. If you create a very stylized model of the world, like the Game of Life, Conway's Game of Life, which is one of the most famous of these models, Conway just died, but nobody thinks that's the real world. It's a grid. You've got a grid of CA running around on the screen. Nobody thinks that's real. But as you start to make it realistic, you move into the uncanny valley where people clobber you if the thing isn't realistic. Now, on the other extreme, you have something like the video game The Sims, which is meant to be like pretty damn realistic. Okay, but in the middle there, it's like if people really give you a hard time because they say, well, why didn't you include this, and why didn't you include this, and why didn't you include this in the model? And what they're really trying to do is say, if it's not hyper realistic, then I can't get anything out of the models. And that's a kind of I understand why people do that, but they just haven't thought long enough about what's the point of doing models in the first place. They're somewhat of abstractions, but they're meant to teach you something about how it all works. It's sort of like if you're building a simulation of that was described earlier. If you don't get every single detail about every case, can you learn something about stock and flow? Yes, is the answer. You don't have to know every single thing in every pleading in every case in order to build a reasonable representation and improve a system. But that's just something people fall into as a trap. Okay. So here's a few papers that use some class of simulation or theoretical representation. I had a PhD thesis which is focusing on laws as complex adaptive systems, so I'll put my own in there. Here's another paper that's looking at the structure of administrative law and uses game theory as a way to represent that. Here's a paper looking at tax compliance, and so people are interested in do people comply with the tax law, and trying to build models of how people's social networks may or may not influence them to cheat on their taxes. This is a paper that my friend Mike Bomberito was involved in, which is looking at this actually is focused on resource extraction rules and governing common pool resources and making sure that what's the optimal level of enforcement in order to get what you want. So that enforcement's a common thing people are focused on, which is one of the things I said, we have rule construction, interpretation, and enforcement. So this is on the enforcement side of things. These are two much older papers, but have created many follow-on analyses. One is to understand, how do cases filter out from all the disputes in the world to all the cases that actually make it to court. What does that winnowing effect look like? And this was just mentioned, but this is a representation of a simulation to support how do you run a court system better. Now, again, is it a perfect representation of all the details? No, but can it be useful? Yes. There's a famous phrase, all models are wrong, some are useful. So let's keep that in mind. Okay. The fifth type of modeling. Modeling user experiences with a given legal process. Law has many processes and procedures. I think even if you're not a lawyer, that would be clear to you. In fact, we teach entire classes on legal procedures. I used to teach criminal procedure, and I used to teach civil procedure, which is literally a class in process about the processes. So law has a lot of focus on processes and procedures. But when we think about, there's another way to think about process, and here's a couple relevant intellectual disciplines. The field of process engineering, operations research, and when it's put through software, we get focused on how do humans and computers interact with one another, which is a subfield of computer science. And it should just be said, the development and deployment of software is based upon models. It's based upon representations of reality. A case management system, a matter management system requires a step-by-step understanding of what the processes actually are, or you cannot represent them in a computer system. One of the things people do is they buy a case management system, and it's always like quite a distance away from what people want because they want to specify it. It's not going to be out of the box exactly like the process that's actually in play. So that what happens is there's a whole, let's call it, group of consultants that spend a bunch of time like trying to tailor a general case management system to how does the actual process work here? So process is critical to understanding how do I take a general software platform and project it into some particular legal process, and that's a big task. Almost never do the systems out of the box even look close to what people really want. The other thing you can do is when you actually map the process as it's playing out in reality, that could support efforts to re-engineer that process. It can also provide a foundational data to support lots of other types of modeling efforts. Now, the good news is there are well-known methodologies for managing process-centric work. There's a field of project management and process improvement. So fields like Lean and Six Sigma, I think of those as a way to translate process engineering paradigms and concepts to a mass audience who aren't, say, engineers by training. Lean and Six Sigma, more on that in a second. But if you look across the economy, there's efforts to take artisanal processes that live between people's ears and convert them into industrial processes. This is a big arc, or what might be called the industrialization of the artisan. This is a big arc of time. I mean, the ideas can be traced back to here, to the dawn of industrialization, or to here. But in the last 50-ish years, we saw kind of the next version of that in the Toyota production system, and that's the origin of Lean. Those are principles for manufacturing automobiles. The question is, there are other process-centric activities, and so Womack and Jones is a famous book about how do we convert some of those principles to white-collar work or knowledge workers, which lawyers and people working in the legal system would be considered knowledge workers. The goal is to keep the artisanal elements that add value, but get rid of the stuff that doesn't. So this is 3 processes. As we think it is, as we romanticize it, whatever, as it actually is, we use this in a class that I teach, and as it should be. Where as it should be is, if one looked at, this is all these steps that add friction, waste, that aren't value add. Now, people will have a normative debate about what it should be, but I guarantee you we can take a legal process and interrogate it, and I'm going to win the argument that you can't justify why it operates that way. Again, if you want to work in empirical reality, if you want to tell some corner case or edge story, that's fine, go ahead. But that's the type of stuff that holds back the progress in these spaces. So if you look at Lean and Six Sigma and other process improvement methodologies, I think they can help every single subsector in law, from the biggest enterprise all the way down to the courts, to help individual litigants. So we have a lot of high volatility processes, and we want to make them more like this. You're never going to get like this, but you go from this to this through process engineering. And you're left with a very useful artifact. This is one individual process step, and this is all the things that are involved in that process step. And this is the map. This is how one thing flows to another, flows to another. These live in people's minds. Individual lawyers have these in their minds. First we do this, then we do this, then we do this. In fact, if you go into a law firm, you'll see things called playbooks. These are all about how do you memorialize these in kind of analog systems, paper and pencil systems, books. How do you translate it into software? Well, you're going to have a process map at some level. These things can help increase response times, increase margins, predict resource loads, and coordinate across lots of stakeholders. I teach a full-length class at Illinois Tech, led by our colleagues at Seyfarth Shaw, which is a top 100 U.S. law firm, where we teach process engineering as part of the legal curriculum, because we think it's important, because we think the law is a process-centric exercise. You should learn something about the methodologies. Maybe I'm lucky because I teach at a law school that's in a technology university, which is a very fortunate thing, because this is not something you see at a lot of schools today. Hopefully more soon. So I want you to think of these process maps as kind of an estimation of the process in reality. When you connect it to data, you can actually illuminate, well, that step in the process that we think takes 2 hours actually takes 6 hours. And, or here's the distribution. Because once you are able to render a prediction about things like, this is what people want. How long is it going to take? How much is it going to cost? Are we going to win? Courts can provide scientific scheduling of cases if they have a process map and they collect data on how long things take. Otherwise you can't do scientific scheduling if you don't know the process, if you don't know you don't have not every case is going to be exactly this amount. It's going to be a distribution. So being able to make predictions. Once you link each and log each node on this process map and do these exercises, then it becomes more reflective of reality. Now, of course, there's always a question of how much detail to go into. A radiculogram is a term of art. That's a joke. It works better in the room, but this question is how much detail do we go into? And once you can make predictions about individual steps, then you can generate predictions about kind of wider phases. So this part of the case has a distribution. How does it look over the whole case? And you can do, this is what people want to know. This is going to take 9 to 15 months in 85% of the cases. This is what people would like to be able to do. But it's the foundational element is to understand the process better. How much will it cost? Things like this. Okay, speaking of prediction, there's a connection here to our last form of modeling, which is predictive modeling of legal systems. Again, these are the questions people ask all the time. How long is this thing going to take? How much will it cost? Will we win? And how do I, if I'm running an organization, whether this is allocating judges or allocating lawyers or whatever, how do I map the problems to the expertise that I have in my organization? So these spider diagrams are helpful kind of ways to see it. Is maybe one thing people have done in this scientific scheduling is they say, well, let's have all the criminal cases go to the judge who was a criminal lawyer, and let's have all the commercial litigation go to the person who's a commercial lawyer, rather than have the person who was a criminal lawyer do the commercial cases where they don't have the expertise, and so they can figure it out. But this is possibly a more rational way to allocate things. I want you to see that there are many prediction problems within law, and I have longer form presentations on this. But remember that the candidate in prediction is you either use this computer or you use this computer. But you got to compute it on some basis. You're either going to use a person or a machine. This computer has a well-known set of flaws in it, by the way, CEG, all of cognitive science, about all the cognitive biases we have. There's a lot of romanticizing of this machine that doesn't hold up in reality. And then there's this other field. There's problems with that too, with bias in computers as well. Sometimes that bias is really a mirror to what's going on with the human process rather than an indictment of the computer itself, but more on that in a moment. So I expand on this over here, 3 forms of legal prediction. You can also say crowds is another way, but it's more, it's in the slides. But computational prediction will lead, it takes you to 2 families of methods within computer science: machine learning and natural language or natural language processing. You want to predict things. Here's just some of the use cases to which you may, natural language processing, by the way, for those who are unfamiliar, some lawyer folks is, think of it as the statistical representation of language, which is critical. I mean, I spent, and when I'm in my law professor role, I spent a lot of time encoding students with the language of law, which is a very formal language that is used in very particular ways. And so machines have to have some account of words in certain use cases. So here's some use cases. Connecting contract terms to outcomes, identifying rogue behavior and bad behavior and compliance with legal rules, just helping people find the right legal information. Again, predicting case outcomes. Again, substantive case outcomes, like, are we going to win, or how much are we going to win? And, how long is it going to take? How much is it going to cost? What's duration? Case scheduling. Again, that's a forecast. I can't slot the judges in a scientific schedule unless I have some notion. I can't triple book the judge, so I got to figure out how long it's going to take and slot their and so that goes for the work allocation. So a prediction model. From a global perspective, there has been significant scientific and commercial interest in this question of predicting things in law and in building and leveraging models in this context. So I'm just going to thumb through these so you get a taste for it without necessarily going into complete detail into each of these. That's looking at costs. This is looking at arbitration. Some people store information about arbiters' tendencies in their minds. The question is how we might store some of that in a database. This is medical malpractice cases. This is tax cases. Securities fraud class action. Decisions of the European Court of Human Rights. Patent law. This is on the transactional side of the world. So force majeure, which was a big deal. It's been a big deal in COVID because people want to try to get out of contracts because of the acts of God. Choice of law, big question in law. You know, which law, you know, people when they're drafting contracts. Lots of things about judicial prediction. This is from the Philippines, Thailand, Germany, Russia, China, Brazil, and this is our paper in the U.S. Here's a couple examples of court administration. This is just was launched from Singapore for the public to be able to try to simulate outcomes and this is in motor vehicle accident cases. So the Singaporean government created this for people you can look at it, motoraccidents.lawnet.sg. This is from China, the 206 system. You can read about that, but that's their massive kind of case management or legal management system that they've launched. But there's much more that can be done, and that's where all of you come in. That's where all of you come in. So I'm going to wrap up now with a few parting comments about law meets STEM: science, technology, engineering, mathematics. I've long believed that a law school and a technical school should meet. That, you know, this is typically how law is taught, as it's like liberal arts, but there's an alternative paradigm. You know, this is the big debate in the academy. It's been going on for a long time, the sciences and the humanities, and it's like this. Well, I think law got slotted in the wrong column personally. It should have been slotted into the technical column, but, you know, I wrote a paper, and I used to say, well, what, you know, if MIT had a law school, it would be world class, but it wouldn't look like the traditional law school as we understand it. So I wrote a paper a number of years ago called the MIT School of Law. And I outline in this a vision of what a kind of law.edu could be. In the years that have followed since I wrote that paper, not because I wrote the paper, obviously, but just, you know, I think other people see a lot of this too, which is, you know, we've seen a number of law schools around the world build, and I've highlighted a few of them already, some credible version of a polytechnic offering. This is the demographic reality, by the way. We're about to have the largest generational transfer in human history. It's a challenge to almost every organization. We have a lot of expertise that's going to leave these organizations. And the question is, I think organizationally, people need different and better human capital in order to support. If you even believe half of what I've said today, then there's a big gap between the world as it might be and the world as it is. So helping solve that complexity challenge in law, we need multidisciplinary people and we need multidisciplinary teams. And this should be reflected in the content of legal education. IBM has this idea of what's called a T-shaped professional, which is a person has depth of expertise. So a lawyer should better have depth of expertise in law, but also has a breadth of knowledge that helps them connect the deep expertise to other problem spaces. So my former student, Imani's founders, this was hers. These are other allied skills that help me combine my legal knowledge with other things: design, analytics, technology, project management, business, basic business understanding. So in this presentation, I briefly highlighted at least 6 forms of modeling that might be leveraged to better understand and hopefully improve the delivery of justice. I've identified various methods and intellectual fields whose work might also be leveraged. Much more could be said in a longer form session, but I think hopefully, at least in part, this helps map the intellectual terrain. and hopefully spurs on a series of fruitful collaborations at the intersection of law and STEM. So I want to thank IIT Delhi and NLU Delhi for hosting me here today. I want to thank the Dash Society for reaching out, inviting me for the talk. And I want to thank Dash Center for Excellence and IIT Delhi for having me as a mentor in their new center. I'm very excited to see this. Obviously, for the reasons that have been outlined in what I've presented, I think you could see why I'm excited about this. And so with that, I'll conclude and open things up. Thank you very much, everyone.
Okay, thank you so much, Dan, for this breezy, if I may say so, but wide overview of the entire landscape of modeling in the justice system. And let me add, if your intention was to provoke, I think you were fairly successful. You provoked quite a bit. But of course, I mean, I'm sure you were also trying to do exactly that and not necessarily,
A diamond is made under pressure, people. You make a diamond with pressure. So there you are.
Right. So great. Thanks so much. There are some questions, Dan, that I would ask before opening the floor to further questions. I've got them from various sources here. So there's a question that goes: would there be a risk to modeling law for laws that were initially created not to be modeled, such as case law under the common law, especially if the country still predominantly uses case law?
No, first of all, you're already doing a model. You do the model up here. So you've already committed to modeling. It's just a question on what basis we're doing the model. So no, there are models I didn't cover. Again, this is a 40-minute talk, so or so. I can't go into all. There are models of the common law that one can build. There's models of the civil law as well that one can build. So first of all, I don't see the danger in modeling. I see the danger in not having a model is more dangerous. And again, there already is a model. It's just in your mind. So that's why I try to say every model I showed you has a corresponding mental model that lives between your ears. And so the question is, if showing people a representation, now if the representation doesn't have fidelity to reality, that's a little bit of a different story. Just remember, this isn't always completely faithful either to reality. So that to me, that's the question. I don't know what the intention of the question was, but I don't personally see the issue.
Okay, great. So I think that's a perspective, and I think we may come back to this in our discussions as we go along. One more question, which I would like to ask you is, how difficult, in your experience, is it to convince the institutional stakeholders to approve the use of modeling for decision making in the law and justice system? So how open are stakeholders to accept this?
Well, it depends on what we're talking about. Or if we're talking about algorithmic decision making where there's no human input, that's one thing. If we're talking about decision support systems and other things like that, that's a little easier for people to accept. The extreme end of this is, algorithms basically deciding cases. That's the kind of what people like to sort of brought out. But, being able to better do assignment of cases to the right person, being able to, have better throughput by not wasting the judicial calendar, where they think the hearing's going to go, then it gets canceled and they have nothing to put in the slot, and then an hour or two is wasted, and then it just propagates over many, many instances. Or, a bunch of other things that are just straight wasteful activities. That those are the things that we want to try to prevent, and having a model will help. It will help. It will help with things like that. I know that algorithmic decision in cases, that's kind of on one extreme of all of this that people have rightful concerns about. The only thing I would say is, when we build models, sometimes it reveals, as I tried to say earlier, it reveals what is true already in reality. Because what we often will do is train it on the existing data. And then, this is what kind of comes up in the algorithmic bias conversation that's out there. The bias isn't the machine's fault. The bias is the system that it's modeling. the model reveals what is true already about it. It's, again, don't blame the computer, blame the system that it was trained on. That's all I would say in response to that.
Okay, great. So one last question before opening up, Dan. Are there any examples of successful software implementation in the legal context of Six Sigma or lean approaches?
Oh yeah, there are many commercial examples of people. I mean, I mentioned that law firm that they have like 500 process maps of all different types of work that they do at the law firm, and that's a commercial example. I guess my point to you is to say, if you're going to do a software deployment, you have to have a process map, implicitly or explicitly, because how in the world would they know what to put in there? The question is, when you go to do that, when you go to, like, say, launch a system like this, it might be a time to ask whether this is precisely the process we want to go with, or if we want to do some re-engineering of that process and then represent it in a system. You could do it as you go. You could just say, what is the system today, and how do I make it work through a case management system or something like this? Or perhaps these aren't the steps we want to have. So I think you're going to have it. Remember, you already have whatever the process is today. It's just in here, and people are living with it and trying to explain it to people as best they can. But having it in a system of record is helpful in that respect. And you can re-engineer it.
Okay, great. Well, so thank you so much. Thanks, Dan, for this talk. And I hope the audience really did enjoy, and I request them to continue engaging.